ఆకర్షణీయమైన చీరలు, అప్పురపరిచే ధరలు, అందరికీ నచ్చిన అందరూ మెచ్చిన షో మన లక్కీ మహిళ. బోలెడంత ఎక్సైట్మెంట్, వండర్ఫుల్ విన్నింగ్ మూమెంట్స్.
ఎగ్జాక్ట్ చెప్పారు, మీరే గెలుచుకున్నారండి. కంగ్రాచులేషన్స్, $220.
సెలబ్రిటీ హోస్టులు, అదిరిపోయే పంచులు, సరదా సరదా కబుర్లు.
ఆశ దోశ అప్పడం బడ హెల్ప్ మీరు ఆడుతున్నారు.
ఇలా మరెన్నో మెమరబుల్ మూమెంట్స్ తోటి థర్డ్ యానివర్సరీ జరుపుకుంటోంది మన లక్కీ మహిళ. Watch it live only on TVASIA Telugu. మీ అందరికీ థర్డ్ యానివర్సరీ శుభాకాంక్షలు.
గెలుపే ఊపిరిగా, పట్టుదలే ప్రాణంగా, ఆశయమే గమ్యంగా పోరాడే యోధుడికి విజయం అన్స్టాపబుల్. ప్రశ్నల్లో మరింత ఫైర్, సర్దాల్లో మరింత సెటైర్, మీకోసం మరింత రంజుగా. దెబ్బకి థింకింగ్ మారిపోవాలా? మీకోసం మరింత రంజుగా.
अब तू देख लेगा बच्चन साहब का खेल.
డౌన్లోడ్ ఆహా నౌ.
ఆకర్షణీయమైన చీరలు, అప్పురపరిచే ధరలు, అందరికీ నచ్చిన అందరూ మెచ్చిన షో మన లక్కీ మహిళ. బోలెడంత ఎక్సైట్మెంట్, వండర్ఫుల్ విన్నింగ్ మూమెంట్స్.
ఎగ్జాక్ట్ చెప్పారు, మీరే గెలుచుకున్నారండి. కంగ్రాచులేషన్స్, $220.
సెలబ్రిటీ హోస్టులు, అదిరిపోయే పంచులు, సరదా సరదా కబుర్లు.
ఆశ దోశ అప్పడం బడ హెల్ప్ మీరు ఆడుతున్నారు.
ఇలా మరెన్నో మెమరబుల్ మూమెంట్స్ తోటి థర్డ్ యానివర్సరీ జరుపుకుంటోంది మన లక్కీ మహిళ. Watch it live only on TVASIA Telugu. మీ అందరికీ థర్డ్ యానివర్సరీ శుభాకాంక్షలు.
ప్రేక్షకులందరికీ hello and welcome back to yet another fabulous episode of our talk show with experts. మనతో మన expert Rebecca Chengaru. Rebecca, thank you so much for being on the show today.
Thank you for having me.
Thank you. For people who are watching us, call our expert on 833-882-8872. The number again is 1-833-882-8872. Watch us on Yup TV, Facebook, YouTube, Sling TV, World BV TV, and Dish Network. All right. I know we started with one topic for today, but it looks like, there's another topic that's sort of overtaken or become the topic of the hour, which is the H-1B lottery. Rebecca, I believe there's been a second round of selections in the H-1B lottery. Can you tell us what we know so far, what we can expect? What are some of the things that people need to do in order to be prepared, of what's coming?
Sure. So we had been expecting for a while now that there would be a second round of selections in this year's H-1B lottery, mostly based on the number of duplicate registrations that we found out about earlier in the year. And USCIS had not confirmed anything until this past Thursday. They basically issued an announcement noon last Thursday saying that there would be a second round of selections. They provided no other information as far as when those selection notices would be coming out or how many additional selections were made. But starting Friday and into Saturday, yesterday, our office at least started getting those selection notices. The way that the selection notices work is it's similar to how people are notified in the first round of selections. Basically, individual applicants, there's no way for you to log on to anything to find out personally whether you were selected. The only way that a selection notice is sent out is to the employer's MyUSCIS account, that the same account that the employer used to submit your registration. And if they worked with an attorney to submit the registration, an identical notice will be uploaded to the attorney's MyUSCIS account. So if you are an employee who had a registration submitted on your behalf by an employer, you'll need to get that information on whether you were selected from your employer or the attorney that they worked with. Unfortunately, there isn't a way for you to log into anything to find out on your own. Right now, so in the past, USCIS has many times taken a few days to finish uploading those selection notices. So we're not, if you've been in contact with your employer or your attorney and they have not yet gotten a selection notice for you, that doesn't necessarily mean you weren't selected in the second round. It's taken a few days typically for USCIS to finish uploading those notices into the MyUSCIS accounts. Normally USCIS will kind of make another announcement when they've said that we're done uploading notices, there won't be any more uploaded at this time, and there hasn't been that announcement yet. So it is still possible that even if you're not selected right now, there is the possibility that more selection notices could roll in the next day or two.
Okay. And Rebecca, can they reach out to any immigration attorney if they want to check their status, or do they have to go through only their, the one that put in the application for them?
Yeah, it will need to be the attorney that worked with the company to submit the registration back in March. Unfortunately, only that attorney that's attached to the registration and the employer contact who signed off on the registration in the portal, they're the only ones who will have access to it, unfortunately. As far as numbers that we're seeing so far, so there have been additional selections, not last year, but in 2021 and 2020. USCIS did conduct additional rounds of selections in the summer. In those past rounds of selections, the number of those subsequent selections were much smaller than the initial March selection. As in our office, at least, and it's still early. Like I said, we could still be seeing more notices. We still have to kind of find out probably tomorrow on Monday amongst all the attorneys in our office to find out an exact number of selections we've gotten so far. But just among some of the attorneys in our office so far, at least for me, I am seeing a higher number of selections in the second round than I have seen in previous years' second round. So I actually have a similar number of selections than I did in March of this year, 2023, which is not usually the case. Usually we see a big percentage of selections in March, and then if there is a second round in the summer, it's a much smaller number. Comparably. Right now, I'm seeing about the same number that I got selected in March and a similar number selected now. Again, we'll have to kind of wait on some of the numbers and data to see what this brings the overall selection rate up to. But, as we've discussed on here before, the selection rate in March of this year was much lower than in previous years, probably due to those duplicate registrations. It was around 15%, I would say, average for most people. So if the selections in this summer round are about the same as were selected in March, that does bring the overall percentage of selection for this year closer to what we've seen in previous years. And so that indicates to us probably that that initial round was impacted by a lot of those duplicate registrations, but also that a lot of people who were selected who had duplicate registrations did not submit applications for each selection that they made. So it does indicate to us that either those people submitted only one application out of maybe 5 selections that they got, or that the kind of threat of fraud investigations, that sort of thing, has been enough to deter some of the people who registered multiple times to prevent them from filing the actual petition in June. So it's not the best system for dealing with fraud. I mean, it makes it very difficult for employers and the employees to plan when they are expecting to get a yes or no on selection in March. Now they have to kind of wait till August, but at least it seems to be getting finally, it's sort of trickling down to people who have genuine kind of single registrations. But as I said, we'll have to kind of wait and see what the final numbers are on where it brings the selection rate up to.
Now, have you all been able to get any information on whether anybody who's put in multiple applications, have any of these people been approved as well?
We haven't gotten that information. I know that Stephen Brown in our office, who kind of heads up the litigation department, has put in a FOIA, Freedom of Information Act request. I don't know if it included that specific request on the number of approvals for duplicate registrants, but he did put in a FOIA request earlier this year to get more of a breakdown on the selections in the regular cap, the master's cap, that sort of thing, more detailed numbers from USCIS on how the duplicate registrations factored into the selection rates this year. It sounds like he may file a similar FOIA request for this second round of selections, but we don't yet have that information.
Thank you so much, Rebecca. Is there anything else you'd like to add to this before we go to our topic for today?
Sure. So also for the selection notices that have come in, the Immigration Service lists on there the filing period. When is the deadline? If you were selected in the second round, when do you have to have your employer submit the petition by? And so the filing window this time is August 2nd to October 31st. And that was kind of what we were estimating when the announcement came out last Thursday. The attorneys in our office were guessing August 1st through about October 30th. So it's pretty much that. August 2nd to October 31st is the filing window for filing a petition if you were selected in this second round. I did also want to mention quickly for anyone who was selected in the second round who is on OPT, if you're, so the same rules about 𝐀𝐓𝐓𝐻 still apply to this second round. Basically, if you have an EAD card from OPT and if it has not yet expired, but it will be expiring before October 1st of this year, you'll want your employer to, and if you were selected in the second round, you want your employer to file that H-1B petition before your EAD card expires. That will give you the 𝐀𝐓𝐓𝐻 extension until September 30th. And then we recommend filing in premium processing so that your status changes to H-1B automatically on October 1st. So there's no gap in work authorization. If you were on OPT, your EAD expired earlier this summer, and now you found out that you're selected in the second round, unfortunately, you are not eligible for the 𝐀𝐓𝐓𝐻 because your EAD already expired. But if you are still in your 60-day grace period and the H-1B application gets filed within those 60 days, you can remain in the U.S. and have your status changed to H-1B on October 1st automatically. The downside is that if this is your situation, your EAD already expired, but your H-1B is being filed now, you can't work until your H-1B status kicks in on October 1st. So you can stay in the U.S. Based on the pending or approved H-1B petition, but you won't be able to work until October 1st. So that's something to keep in mind if you are an OPT and were selected in this second round.
Got it. And when does this sort of second line window close, you know?
October 3rd. Well, for the selections, we're not sure yet. Our guess is probably, my guess is probably by end of day Monday. Most likely.
So that's pretty short then.
Yeah. In the past, it's been about 3 days or so, especially for the second round when typically there hasn't been as many selection notices to upload. Usually USCIS finishes uploading anything that can be uploaded within about 3 or 4 days. So because we started getting the first notices on Friday, my guess is by end of day Monday, most likely we'll see, you know, all the selection notices that we will get in this second round, but we won't know for sure until USCIS announces it.
Okay. Thank you, Rebecca. And let's talk a little bit about, you know, the topic that was sort of, you know, assigned for today about, you know, priority dates and, you know, why they move back and sort of, you know, what is retrogression? Why does it happen in employment-based immigration? You know, what's the need for it? What are some of the good things? What are some of the cons of, you know, having it?
Yeah, mostly retrogression, I would say, happens mostly because of the government's failure to properly estimate how many application I-485 and immigrant visa applications that they will get. Basically, the priority dates are set each month by the State Department. They say they're in coordination with USCIS also. It's been hard to determine how much information sharing there really is, but basically the setting of the priority date every month is supposed to be based on the government's estimate of how many applications that they will get in response to whatever priority date they receive. When USCIS overestimates or underestimates that amount, they set the priority date too far ahead, and in response they get more applications than they were expecting. When that happens and the category becomes what they call oversubscribed, that means they got more applications for EB3 India, for example, than they were expecting based on whatever priority date they set. That's when they move the priority date backwards, basically to stop people from submitting any more applications because they know that there aren't any any more green cards left in that category in EB3 India, for example. So it is sort of a case of the government not being good at estimating how many applications they will get. But specifically, I would say the retrogression that we're seeing the past few months in India, EB1, 2, and 3, that is kind of a combination of factors. I mean, this fiscal year, we actually have more green cards than a normal year. There has been spillover this year. So in a normal year, there are 140,000 employment-based green cards for India. This year, there was some spillover so that there was 197,000. So there were more than usual. But unlike the last 2 years where there were also spillover, dates have gone backwards this year, which has been perplexing for people. The factors that are leading to that retrogression this year where there wasn't the past 2 years is, number one, more people are filing in EB1 than before, not only in India, but for the rest of the world. So a lot of the additional, in the past when EB1 wasn't being, the number of green cards allocated to EB1, in the past when they weren't all used up, those extra EB1 green cards would trickle down to EB2 and then EB3. So that's where there would be more forward movement for EB2 and EB3 India, potentially. Right now with EB1 being all used up, not only for India, but the rest of the world, there's none to trickle down to the EB2 and EB3 categories. In addition to that, there has been more applications than usual for EB3 rest of world. So that category, the rest of world category, is basically EB3 for anyone whose country of birth is not India, China, Mexico, or the Philippines. Historically, that category has not seen its maximum demand. The number of green cards set aside for EB3 rest of world usually hasn't been all used up. So those numbers would also kind of trickle across to India, which has always needed more. Now that EB3 rest of world is also all being used up, that also means there aren't enough to trickle over to India. And so it seems like it's just in the last couple of months that the government has realized that basically that all the green cards that are available for these categories for India have already been used up for this fiscal year. The fiscal year doesn't end until September 30th, but basically the government did their numbers and realized all the available green cards that there are for India this year have already been used up by early summer. And so that's why they have so aggressively moved back the dates for India in particular. It's mainly a way for the government to turn off the flow of incoming new applications for the rest of this fiscal year. Basically, they don't want to receive any more new I-45 applications for EB1, 2, or 3 India because they've already used up all the green cards for this year. So some of the backwards movement in the priority dates for EB1 in particular, we're expecting that kind of aggressive backward movement is relatively temporary. Because when a new fiscal year starts October 1st, there will be a new batch of green cards and they go to EB1 first out of any of the categories. So we are expecting that EB1 India will kind of recover to about where it was in spring of this year. It'll most likely recover pretty well. The same is not necessarily true of EB2 or 3, definitely EB3. It may not move forward very much because it always depends on trickle down from EB1, trickled over from rest of world, and because those categories have been used more than normal the past couple of years, if that trend continues, then EB3 may continue to kind of be stuck quite far in the past, unfortunately.
Gotcha. And Rebecca, I had one other question about this, but I'll get back to that in a short bit. what else can you tell us about, what about this retrogression, and what's going to happen in the near future? Like, is there something
Yeah.
that we know about it?
Well, we'll have a better picture, I would say, when the October Visa Bulletin comes out. So that should be mid-September. So,
Okay.
About 6 weeks from now, hopefully, when the October Visa Bulletin comes out, we'll have a better picture of what the state of EB India categories is, because there will be kind of a new batch of green cards. Hopefully, the government has gotten better at sort of calculating the number of applications that they are bringing in or expect to bring in, and won't do this, forward movement and then overcorrecting to, move so dramatically backwards. But yeah, that'll kind of be yet to be seen. As I mentioned, our best guess is that probably EB1 India has the best chance of kind of recovering to a more reasonable date in the October Visa Bulletin. It's harder to say about EB2 or 3.
So just out of curiosity, if I remember right, EB1 is always like a more, sort of has more stringent rules, and, you have to be, especially qualified, and, like a scientist, or, someone with like multiple PhDs, or, someone who's like super famous and stuff like that. What has caused this sort of sudden surge? Because it used to be hard to even convince people to, even convince attorneys to say that, hey, can we do this in EB1 category for me? So what has changed,
Yeah, definitely. I would say one major change has been the Biden administration. So I would say during the Trump administration, all applications were more difficult for every reason, but definitely EB1, I would say there was a very high standard, as you mentioned. It is still a high standard. EB1A is still meant to be for, the people at the top of their field. It's the extraordinary ability category. And so it does require a high standard of achievement for those applicants. But I would say under the Biden administration, they have gotten more flexible in terms of their interpretation of some of those high criteria. They released some guidance actually pretty early on in the administration about STEM applicants in particular. Basically, the administration's prioritizing of applicants in the STEM fields, and released some guidance on EB1A and NIW, actually specifically to kind of encourage USCIS adjudicators to kind of think more creatively about the EB1A criteria. There was no change in the criteria themselves. The requirements are still the same as they always have been, but there was guidance to suggest other types of evidence that should be taken into consideration, especially for STEM candidates. So that kind of flexibility on the part of the Biden administration has led to more approvals in EB1, where I feel like those same applicants under the previous administration probably would not have been approved. And so when there are more approvals, that encourages more people to give it a try, to try applying. Also, the movement in the priority dates the last few years from, the sudden jump forward in 2020, and then the sudden move back, the past couple of years, it has kind of encouraged more people who normally wouldn't have thought of EB1, but, who got so close from the 2020 filing. If they, were able to file the I-485 in 2020 and they just didn't get their green card in time before they ran out last year. A lot of those applicants, I believe, have been kind of encouraged to, or been motivated to try for EB1 because they got so close. They see where the dates are now. They want to look at any possible option to finally get their I-485 to the finish line. And so a lot of people have been considering EB1 who perhaps were not before because of this back and forth of the priority dates.
Got it. Thank you, Rebecca. All right. Let's take our first caller for today. Okay, caller with a number ending in 0279. 0279. We're ready for you. Hello.
Yeah, hi, Nitya. Hi, Rebecca.
Hi, sir.
Hello.
Yeah, hi. Can you hear me?
Yes, sir, we can hear you, sir. Please go ahead. Thank you.
Yeah, hi, Nitya Garu. Hi, Rebecca. This call is in regarding to one of my cousin's situation. Actually, he got picked up the lottery and he was notified by his employer on Friday. But unfortunately, yesterday he informed him that, he also gave his application to one of his friend's company and they also submitted his application. Whereas before in January, he told his employer and he sent him a message saying that he just wants only him to submit the application, and without his knowledge, his employer gave his application to the other company and they also submitted his application. And he just came to know yesterday that there were 2 applications on his name. So here my question is, should he submit the application or should he set back?
So do you know, are these additional registrations, but was he selected already in March and a company already submitted an application for him by June 30th? Or is this the first selection?
No. He was, this is the first selection. He got selected in the second lottery.
Okay, but there were more than one registered for him in March without his knowledge?
Yes.
Okay.
Yes.
Yeah, it is really difficult. So unfortunately, I would say if the companies that submitted the registrations for him in March, if there is a relationship between those companies, basically, common owners, common attorneys that filed the registrations, anything that UCIS can find that relates the companies, it probably is safest if the application is not filed, even if the employee had no knowledge that the registration was being submitted on his behalf by a company he had no idea about. From USCIS's perspective, that is a duplicate registration, and it is basically fraud on the part of the employer. I don't think your cousin in particular is in any danger of, a fraud prosecution necessarily if he genuinely was not aware, but the employers that filed the registrations definitely are at risk. And if you were to go forward with an H-1B petition, it could then pull your cousin into, being questioned. USCIS will always question whether he knew about the duplicate registrations. First of all, the application would probably either not be approved or be approved and then revoked, because USCIS has been getting better at, identifying filings based on multiple registrations, investigating them, and, sending these notices of intent to deny or revoke that specifically list out for this beneficiary, this company, this company, and this company registered him. So yeah, it is very difficult. It sounds like it wasn't, through any fault of your cousin in particular, if you didn't know, but unfortunately, I think it's safer if he does not have a registration submitted for him and that he tries again with a completely different employer next year in the lottery.
Okay, this doesn't affect him for the next year submission?
If he does not go forward with the H-1B filing, I would say there should be no effect for future filings. As far as we know so far, that's based on what we've seen so far. The main kind of target of USCIS investigations has been companies, not individual employees.
So you just want us to submit a different application next year with a different company, not with these companies.
Yes, I would say so.
Okay, thank you. But the employer said they don't have any connection, like any transaction in between both the companies. A penny transaction also. It's a different lawyer, different company, different client.
Well, the wording on the
So still-
USCIS registration portal basically says that the company has to verify that they have not colluded or cooperated with any other company to submit the registration. So they don't necessarily have to have common ownership or be related, but if they shared the employee's information with another company in the, with the intention of increasing the chance of selection, then that is fraud according to USCIS.
Rebecca, do you recommend that someone like this can take all the information and, approach a different lawyer just to sort of see if this is, something that they can check out and verify and make sure that, this is not the case?
It is really difficult because in the portal, the only way that there unfortunately is very little that an individual employee can verify about who is registering them, whether a company has actually registered them, and whether the company has registered that employee under other companies they own or other unrelated companies. The registration portal is only accessible to the employers and the attorney that is linked to that employer. So unfortunately, probably short of a Freedom of Information Act request, it's very difficult for the employee or, an independent outside attorney to verify whether that employee has been submitted, how many times that employee has been submitted without their knowledge. So it's really up to the best that employees can do to kind of protect themselves against that, I think, is to just try to file through a single employer that is kind of, reputable, does not have a track record of trying multiple registrations, who, ask the employer to verify that they are only submitting them under their company, which isn't much. Like I said, unfortunately, the accessibility by the employee in the portal is very limited.
Okay.
Okay, I understand that, but there will be no risk for him on his side for submitting next year, right? Because of these multiple applications this year. I'll tell him not to submit the application, but
right. Like I said, if he, if he does not have the go forward with this H-1B application, I would say there shouldn't really be any risk in him being submitted through a completely unrelated company next year in the lottery.
Okay, thank you. Thank you, Rebecca. Thank you, Nitya garu.
Thank you, sir. Thank you so much for calling in.
Thank you, bye.
All right. Rebecca, before we take our next caller, I have a question for you. This is from 𝐀𝐓𝐓𝐻 Creations. He says, he or she says, can I take my father to Barbados for extended stay on a visitor visa instead of I-94 extension?
Oh, let's see. I am not really equipped to advise on kind of what the requirements are for entry into Barbados. Most of what I know is that if you are traveling as part of a cruise, for example, going to some of the nearby islands in the Caribbean, a lot of times you are not necessarily issued a new I-94. Every time you get off the ship to, visit the islands in the Bahamas, you're not issued a new I-94 when you come back. I believe when you come back to the U.S. on the ship that you are issued a new I-94 because that is a new entry. Let's see, parents I-94. Oh, I don't know if this is a different one, but
this is a different question, but yeah, it's unrelated. Sorry.
Yeah, I am not sure on that one. I would say that basically the best thing to prepare for if you are going to Barbados is to make sure you have the proper documents. If you need a visa to go there, to make sure you can enter Barbados and that you have a valid U.S. visa to return to the U.S. afterwards.
Got it. Also, I have another question here. This is from Viraj K. It says, I'm moving to Canada under the Canadian H-1B scheme. Can I apply for a B1, B2 visa from Canada for continuing medical treatment in the US? I have my H-1B stamped until June of 2025 and I-140 approved. Will it impact my H-1?
It could impact your H-1 because they may, if you apply for a visitor visa, they could cancel your H-1B visa. So I would say you need to decide, basically, if you're relocating to Canada, you don't really need the H-1B anymore. Even if you're going to be working remotely for the H-1B employer from Canada, you don't need an H-1B visa in order to do that. If you're authorized to work in Canada and you're sitting in Canada, you can work for a U.S. employer and you don't need any U.S. immigration status or visa or work authorization in the U.S. if you will be sitting in Canada. So I would say that is probably the best way to go if your plan is to relocate to Canada for an extended period of time, but you plan to come into the U.S. for a purely visitor reason, which coming in for medical treatment qualifies, it falls under the B1, B2 visitor visa purpose. So if you're going to be coming in just for that, that would be the best thing to do is to apply for a B1, B2 visitor visa. You can apply with the U.S. consulate in Canada. If that is where you're going to be based, you don't necessarily need to travel back to India to apply for that. But be aware that they could cancel your H-1B visa. I've seen it both ways, where some consulates, basically, if you can make the case that you are still employed by the H-1B employer and will be coming into the U.S. on the H-1B visa to work, but not on this specific trip, they could potentially issue you the B1, B2 and let you keep the H-1 for when you will be coming in for work. But because that's a little difficult, that's a very fine line to distinguish. Be aware that if you do apply for the B1, B2, the officer could cancel your H-1B because they'll say that, you're going to be coming in for a visitor purpose, not for work. So they may cancel the H-1B. It doesn't, they'll mostly cancel it without prejudice, which means it's being canceled through no fault of your own. It's not like it was canceled due to fraud or, anything like that, or the petition being revoked. They're canceling it because you are switching to a different visa category that is unrelated. And so it doesn't affect your ability to reapply for the H-1B in the future if they do cancel it, but just be aware that that might happen.
Thanks, Rebecca. I have one other question. This is from Liza Gonzalez. She says, my parents' I-94 expires on December 20th of 2023. The 10-year visitor visa they entered on in June of 2023 expires in August of 2023. Can they stay in the I-94 expiry date?
Yes.
Okay, till the I-94, I guess.
Yeah, that is a common misconception, and it is kind of misleading because we always talk about visa status, and then you look at the visa in your passport, but actually, the visa in the passport and the end date on that visa in the passport only governs how long you're able to use that visa to apply for entry into the U.S. if you are outside of the U.S. Once you are within the U.S., your authorization to stay in the U.S. Is governed no longer by it's not governed by the visa in your passport, it's governed by the I-94. So if you are within the U.S., then your ability to stay here, how long you can stay here, and the status that you are here in depends on the electronic I-94 that was issued when you entered, and that you have to go online to the I-94 website, type in your passport details, and pull up that I-94 record. So in the case of this question, yes, the parents can stay to December 2023 if that is the end date on the I-94 on the website. The visa in their passport will expire, but that is fine. Mostly what the expiration of the visa in their passport means is that, for example, if they stay in the US until September of this year, and then they depart, they can't come back in using that same visa because it expired in August. They'll need to go to the consulate, apply for a renewal of a new visa in order to use it to come in. But if they are not going to depart, they can stay in the US until December, but they will need to plan to apply for a new visitor visa from the consulate for their next trip, because the one they have will have expired.
Okay, cool. Awesome. Thank you so much. Let's take our next caller. Okay, caller with number ending in 1525. 1525. We're ready for you now. Hello.
Hi, Jyoti garu. This is Sri. How are you?
Hello, sir.
Hello, can you hear me?
We can hear you, sir. Please go ahead.
Okay. So my situation is that, my situation is that my 485, I just got my interview letter to attend the interview for GC.
Mm-hmm.
Okay. But my spouse did not get an interview letter. So I applied under employment based. So should I expect her notice also to come, or is it okay to bring her to the interview even though she did not get the notice, or can I just go alone?
Yeah, that is very common. Unfortunately, for whatever reason, USCIS doesn't always send notices for the entire family. Interview notices are not always sent for the entire family at the same time. I don't know why. I would still have your wife come with you to the interview. She won't have an interview notice, but she should bring her I-485 receipt notice and kind of all the same documents that you will be bringing to the I-485 interview. What we've seen in the past is sometimes the officer does intend to interview both of you, but for whatever administrative reason, a notice was not sent in her name. It was only sent in your name. So if she doesn't come with you, they might mark her like absent from the interview, or she would need to be rescheduled for another time, and it becomes difficult. So it is safer to bring her anyway, in case that's what happened, in case they intended to interview her but just did not generate the notice for whatever reason. It is also possible that they are intending to interview her on a separate date. We have also seen that sometimes, when for some reason, even though families file the I-485s together at the same time, the family members are interviewed at different times and their I-485s are approved at different times. Sometimes that is also possible. If that is the case, then so just keep an eye on the mail, until your interview date. If a notice comes for your wife that has a separate date and time, then just have her plan to come in on that separate date and time. If no notice comes in for her at all, then I would just have her come with you anyway to your interview.
Okay. So they would allow us inside, right? They would allow
They
her
should.
also inside.
Yeah, it kind of depends on the security at the front. So usually at the field office, you'll pass through security first and they'll ask to see an appointment notice. If you show yours and say that your wife is with you and she applied along with you, usually they will allow both of you in. I've heard of a few situations where officers said, no, if she doesn't have her notice in her name, she can't come in. If that's the case, then just have her wait in the car or in the parking lot and kind of be on standby. And then if you go into the interview and the officer asks, where's your wife? We wanted to interview her too. Just tell them security wouldn't let her in because she didn't have a notice in her name, but she's out in the parking lot. We can bring her in, and they'll usually have her brought in that way.
Okay, ma'am. Okay, ma'am. Thank you. Just one last question is that actually on the notice they have written birth certificate. They did not write either original or copy. My original is back in India. So can I take just a copy, and also I have the notarized form from my parents original. Can I bring these two to show as birth certificate?
Most likely that will be fine. Although if there is time to have the original shipped to you, I would recommend that. I would say most of the time in the actual I-485 interview, it's pretty rare that I've seen the officer actually ask for the original birth certificate unless they have some kind of question about it, which is rare. It's still safest to have the original birth certificate with you. So if there is time to have it shipped to you before the interview date, I would recommend doing that. But if it's not possible, probably you'll be fine bringing in the copy and the notarized certificate.
Okay. Yeah, that calms me down. Thank you so much.
All right. Thank you, sir.
Thanks
Thank
a
you so
lot.
much for
Thanks
calling
a
in.
lot.
All right.
Thank you.
Let's take our next caller. Okay, caller with number ending in 1470. 1470, we're ready for you now. Hello?
Yeah, hi. Can
Hello?
you hear me?
Hi, sir. Thank you for calling. We can hear you, sir. Please go ahead.
Yeah, I have a question. I have filed my I-485 in October 2021. So I recently received a receipt notice. And in the receipt notice, they are asking to get a medical if it is filed less than a year. So my case was filed more than a year. When I filed initially, I have sent the medicals included in it. So what do you recommend? Should I do the medicals again and carry the newer one, or is it good? Like the medicals are valid till 2 years, right?
So the notice that you got recently was an RFE or it was an interview notice?
It's an interview notice.
Okay. Okay, so the medical, it wasn't a specific request for the medical. It's just on the interview notice. They have like that standard text and it lists.
Yes, they have a 10 point.
Okay.
Yes.
Yeah, that is kind of, a standard list that they include on all I-485 notices. Basically, if you did not submit your medical before, they're telling you to bring it now. So if you did submit a valid medical exam previously with your initial filing, you should not need to bring another one. If they wanted you specifically to bring another one, usually they would issue a request for evidence. That would say specifically bring in, a new form I-693 medical exam. If you didn't receive an RFE like that and the medical exam is just one of the items on that standard form list of documents to bring, then you do not need to go get a new one.
Okay. Yeah. Thank you. That's all I have. Thank you, Rebecca.
All right. Thank you, sir. Thank you so much for calling. All right. Before we take our next caller, Rebecca, I have a couple of questions for you. First question is from S. He says, some job scammers have taken my H-1B copy, driver's license. Will this have any impact? I'm assuming they've taken away his H-1B. He's probably wondering if, applying for a driver's license with a copy of the H-1B will have any impact on getting his license.
Let's see. It shouldn't have an impact, I believe, on applying for a new driver's license because that isn't really the main thing that they'll verify for a driver's license is whether you're in status now. So if you have a valid I-94, usually a DMV will always issue you a driver's license. Depending on what documents they took, definitely you may need to report it to DHS if they have or to the Department of Labor Wage and Hour Division. Yeah, it depends a lot on the specifics of what happened, what documents they took, whether you actually onboarded with them and they never paid you, or if you just sent in your documents as part of the application process and never heard from them again. So I would probably recommend consulting privately with an immigration attorney to kind of discuss the specifics and determine what you need to do from there.
Makes sense. All right, thank you so much. One other question. This is from Gangadhar. He says, can an H4 EAD candidate start a company in the US? If so, what type of companies can he or she start?
Yeah, definitely. If you have an EAD, it is unrestricted work authorization, so you can be a business owner and start your own company. And there isn't any restriction really on the type of business that you start. It could be an S Corp, an LLC, kind of. Usually it's best to kind of consult with a CPA or a local attorney, employment attorney in your state to determine based on that state's kind of tax situation, what is the best corporation setup for your business. But immigration-wise, there isn't any restriction on the type of business that you can set up as an H4 EAD holder. One thing that we do recommend for people starting a business on H4 EAD is to kind of have a backup plan in case there's a situation where there's a gap in your EAD work authorization. EAD work authorization gaps are not as frequent a problem anymore ever since the litigation a couple years ago that has given kind of an auto extension ability to H4 EADs. This was much more of a problem about 3 or 4 years ago when there was no auto extension and you know, the H4s and EADs were being processed separately from the H-1B. Now that they are being processed all together and basically you can premium process an H-4 EAD, the main thing is to make sure that there's no gaps in your H-4 EAD so that you're not running your business without work authorization. But just as a backup, if you're, you know, for an H-4 EAD, you're still dependent on the H-1B visa holder always maintaining their H-1B. So if there is a risk of job loss for the main H-1B applicant, for example, something like that, we have recommended sometimes in the past to have like a business partner or, you know, a partial owner who is a green card holder or a U.S. citizen who, even if they own a small share of the company and are not that involved on a normal basis, if there's a situation where your EAD is not valid for some reason, they can jump in and run the business in your absence until your EAD can be reinstated.
Got it. Makes sense. Thank you so much. All right, let's take our next caller. Thanks, Rebecca. Okay, caller with number ending in 5047. 5047. We're ready for you now. Hello?
Hi, Rita. Hi,
sir.
Rebecca. Hi.
Hi.
Are you able to hear me?
Yes, sir, we can hear you. Please go ahead, sir.
Yeah, actually, I have one question. My wife is on H4 EAD. I have a question like, can she do any business? Can she start any company on H4 EAD status while she's working?
I think we
some
just
other company?
answered your question. Are you Gangadhar?
Yeah, Gangadhar, yeah.
Okay. We just answered your question. If you were watching the show, Rebecca has given like a plethora of information for you to check on there with some caveats as well. So if you can, then just please go back to that section and check.
Yeah, I have one more question. Yeah, I have another question. Like, she has a H4 validity until December 31st this year. Can she still continue working on H4 EAD for another 6 months? While the H4 EAD renewal is on process?
Yes. So with the EAD auto extension policy now, so she can only the auto extension only extends as far as her H4 I-94 is valid. So if her EAD renewal has been filed by December 31st and her H4 status has been extended beyond, let's see, the end of June 2024, then that auto extension policy applies to the EAD, and she could continue working while waiting for the EAD renewal to be approved. But like I said, that only applies if her H4 has already been extended beyond mid-2024 at the time that the EAD is filed. So if her H4 is also pending alongside her EAD, that auto extension doesn't apply. If that is the situation, then what you want to plan to do is there are kind of two options, because now that the H4 and EADs are bundled together with an H-1B, if there's any possibility for you to file an H-1B before December, even, you know, if your H-1B is due to be extended, that's the best case scenario because it has to be filed anyway, and her H-4 and EAD can be filed along with it, file it in premium and get it approved hopefully before December 31st. If your H-1B is not due to be extended anytime soon and your company isn't really amenable to filing an early extension, the main other option for your wife to extend her H-4 is to travel to Mexico, for example, that margarita switch that we talk about a lot, travel to Mexico and come back with your extended H-1B approval notice to get a longer H-4 that way. So those are kind of the main options, but make sure if she is going to try that, if she does not have a valid H-4 visa stamp, she needs to travel and come back before December 31st.
Got it. Thanks for the answer, Rebecca. I have one more question. Can she work for more than one employer on two separate W-2s at the same time?
Yeah, on EAD, it is as flexible as you want it to be. She can work for multiple employers. You know, she can work part-time. For some employers, she can work for an employer on W-2 as well as running the business. That all of that is fine as long as the EAD is valid.
Okay. So is there any restriction like she should be able to fill only certain number of hours per week, like 80 hours or see per day we have total 24 hours, right? Is there any time duration restriction like she should not submit the timesheet with more than 80 hours?
No, there's no.
How much are you planning to make your wife work? Oh my God.
No. I'm just trying to get some information.
I have
because
only
I
24
saw
hours in a day. How much did you work? I'm like, my head is like spinning here. Oh my goodness.
I was looking at one of the video from Reddy. He was giving some kind of information like in case if the person is working for more than 24 hours, I mean, he can do more than one job, right? In case if she is filing more than 24 hours timesheet per day, will that be a problem during GC process? Like, I just want to get some kind of clarity on that.
No, there's no restriction on, the number of hours that an EAD holder can work. Yeah, even if it's for multiple employers. Yeah, it's as much as she is able and willing to.
I remember Rahul was telling us that his wife at one point was filing 8 W-2s. So, you know, she was working for 8 concurrent jobs at that point. So you can just but I don't know how many hours and all, but he did say that, you know, she was filing 8 W-2s. So I'm you know, and he would always say if you're working any less than like 80 hours a week, you're lazy. Which makes me extremely lazy by that standard, but you know, that's what he would generally say. So I'm just relaying that, you know, episode, you know, his statement from that.
Okay.
Thanks, please take care of your wife, sir. We don't want her calling in and saying, "What have you guys told my husband? He's making me work 24 hours a day." All right.
Because the thing is, she will be working remotely. So I mean, I am also working on same kind of technology. So at the back end, I can also help her and try to do my best to make some more
that's
money.
too much information. We don't need to hear. Okay, we have
Yeah.
part of it.
She is very flexible, but if you are on H-1B, remember you
we don't want
are
to hear
authorized
that.
to work for your H-1B employer.
So we don't want to hear any of
got
that
it.
part. Please keep that offline. But all the very best. Thank you for calling, sir.
Yeah. Thanks, Nitya. Thanks, Rekha, for your time and giving me answers for all these questions. Thank you very much.
Thank you.
Yeah, bye.
Rebecca, we have one question. This is from 123 Boys. He says, is the master's quota of 20,000 H-1B still unfulfilled after the first round of lottery?
Yeah, we don't have that information quite yet. I don't think USCIS has announced whether the master's cap has been fulfilled. Usually they do make an announcement when the master's cap and the regular bachelor's cap have been fulfilled. And as far as I know, they haven't announced that either way. I am kind of curious to go through the selection notices in our office. I did notice the ones that I have looked at personally. So far, they have mostly been under the regular cap. I have not checked whether any of them have mentioned master's cap. So if you were submitted in the master's cap, you can still be selected in the regular cap. It's basically that if you are submitted in the master's cap, you have kind of two tries. USCIS will do a selection for the master's cap, and then if you're not selected there, they'll put you in the pool for the bachelor's cap, so you kind of have a second chance. And I do remember seeing that some of my master's cap applicants, their selection notice said that they were selected under the regular cap, but I don't recall actually if all the selection notices said regular cap. I'm a bit curious to go through and check that now, but so far USCIS has not confirmed.
Also, Rebecca, what has been the percentage of total selection in terms of, in the applications filed by Reddy and Newman?
For our selection rate, for the first round of selections in March, I know that within our office, we were at about, I think, a 15% average, which was about in line with what it sounded like it was among other immigration attorneys. Generally, about 15 to 17% seemed kind of typical. With this second round of selections factored in, like I said, we're still waiting to see if there are additional selections that are going to come in the next day or so, and we still have to kind of go through the data in our office to look at what it brings the total selection rate for this year up to, factoring in the second round of selection. So we don't have all of that data yet, but just for my cases, like I said, because I have about the same number of selections in the second round as the first round, it seems to have kind of almost doubled the selection rate for me personally, at least. And then, so, we'll need to see among our office in total, and also by, the time the selection notices have finished being uploaded for the second round.
Got it. Thank you so much. Okay, let's take our next caller. Okay, caller with number ending in 4864. 4864, we're ready for you now. Hello?
Hi, am I audible?
Yes, sir, you are. Please go ahead.
Hi, Rebecca. My question is, with my current employer, I'm on H1 and I do have an I-797 for my wife as well. So let's say I change my job. Do I need to have her H4 filed with another employer as well if we are to go to India and come back on stamping?
Sorry, okay, so you're on H-1B, your wife is in H-4 using the EAD, and you're considering changing employers, is that right?
Yeah, she's not on EAD, she's just on H4.
Okay.
So
Okay.
we already have an I-797 till like 2025.
Okay. And has your
So does
H-1B
she need to
transfer
have her
been?
H4? No, that has not yet been done. I mean, I'm just
Okay.
asking for her. I mean, if we travel to India, do we need to file her H4 as well, or can she just have stamping on the previous employer as her H4 is still valid till 2025?
Yeah. Yeah, it's not necessary for your wife to file the I-539 application along with your H-1B transfer. As you mentioned, right now, her H-4 status is valid until 2025. And then if you are planning for her to travel, before 2025, she can come back then with your newest H-1B approval by then, and she will get the H-4 automatically extended at the border. So as long as you know that she will be traveling before 2025, then it's not necessary for her to file a H-4 extension along with your H-1B transfer, because the H-4 is not company specific the way that the H-1B is. As long as you are in valid H-1B status with a company, then her H-4, as long as it's unexpired, is still valid.
So the visa stamping that she will have can be on my H1, based on my H1, right?
Yes. Yeah. So if she has a valid H-4 visa stamp in her passport now that was stamped based on your current employer, she can still use that same H-4 visa stamp. As long as it's not expired, she can use it in the future to come back into the U.S. She just needs to make sure that when she is coming into the U.S. that she shows your most recent H-1B approval notice, which will be with your new company at that time. So probably that approval notice should have a 2026 end date on it. So she needs to make sure to show that approval notice when she's coming in at the border, not your old 2025 approval notice.
Okay, yeah, got it. And just one more question. So I heard today that some congressman has sent a letter to Secretary of State stating that all EB1, EB2, EB3 be made current. So is that true? And if it's that, if it's true, then what chaos will it create on 1st of October?
I have not heard that news specifically. That would be great if it happened. I don't know that a letter from a congressman could necessarily do that because the numbers are kind of based on a statute, and a single congressman wouldn't be able to change that with a letter. Congress as a whole could, collectively pass legislation to increase the number of green cards, but that seems unlikely. They haven't been able to pass anything really significant immigration-wise for many years. If what the congressman's letter was recommending to USCIS was some of the recommendations that we've made, which is, for example, stop counting family members toward the employment-based green card quota, a recommendation like that, it wouldn't require a change in law. It wouldn't require like a change in statute that requires all of Congress. It's something that USCIS could change in their own policy, which as a result would move the priority dates forward significantly. I don't know that it would make everything current, but it would affect forward change immediately in the visa bulletin. And so that's something that we've been advocating for a while, that USCIS can do on their own, just as a policy change in, how they interpret, how they count the number of green cards. It doesn't raise the number of green cards from what Congress set. It just takes out, spouses and children are right now being considered, they get one of the employment-based green cards, even though they were not sponsored by an employer. They're just accompanying the worker who was sponsored by the employer. But, a family of 4 is taking up 4 EB green cards right now, rather than just 1. USCIS could count that as 1. Right now, they're choosing to count it as 4. So if they just change how they choose to count those green cards, that would immediately move priority dates forward. If that is what the congressman was recommending, then that, hopefully that is the case. The more pressure that can be put on USCIS by not only, applicants in the community, but by, Congress people, the more the better. So if it was a recommendation along those lines, then yeah, hopefully that is something USCIS would take into account.
So recapturing 190,000 visas that were there
That
since
too.
1990 to 2021,
Mhm.
that I believe does not need to go through the Congress, right? That
Exactly.
USCIS
Yeah,
can do.
that's another policy recommendation that we've been advocating for that wouldn't need to go through Congress. It would just be recapturing previously unused green cards that, you know, were there, they just weren't used. That would also, I don't know if it would make the dates all current, but it would also move the priority dates forward significantly.
Okay, thank you.
Thank you, sir. Thank you so much for calling, Andy. Let's take our next caller. Okay, caller with number ending in 0683. 0683, we're ready for you now. Please press *6 to unmute your line, Andy. Caller with number ending in 0683. Hello?
Hi, good evening, Nitya. Good evening, Rebecca. My question is, my green card is approved in EB1 a month ago. So a few of my friends, they are suggesting like not to change the job until 6 months for the citizenship. So is there any like challenges if we quit before 6 months?
No, that is a rumor that we know is out there, and there are even some immigration attorneys who advise that, but there is no requirement in the immigration regulations that as a green card holder, you are not required to stay with that employer for a certain amount of time. You know, the green card issuance is based on a genuine job offer from the company. So as long as throughout the I-140 process, the I-485 process, as long as there existed a genuine job offer from the I-140 petitioning company throughout that time, that's all that's required for your green card to be issued. It's not even required that you have worked for the company at all for them to sponsor you for the I-140. You could have been, you know, abroad.
In the next company, is it the same job I need to continue, or is it okay if I change a role?
Yeah, you could stay with the same company and go into a different role. You could change employers entirely. You know, the AC-21 regulations, for example, allow you to change employers even before you get your green card. So it shouldn't, you know, there's no requirement that even after you get your green card that you stay with the company for a certain amount of time.
Okay. Thank you. Thank you. That's good info. My second quick question is, can we sponsor siblings green card during when I'm in green card, or it should be during citizenship?
Yeah, unfortunately, you wouldn't be able to sponsor siblings as a green card holder. You would need to be a U.S. citizen in order to sponsor siblings. And even then, it is a very long wait, unfortunately, for siblings being sponsored from every country. It's kind of has the longest wait out of any family-based category.
Yeah, I think for India, around 18 years is there, right? Is it possible to sponsor EAD and SSN as soon as we initiate that?
Also, unfortunately, not. So you could, yeah. You could file the I-130 at any time. The I-130 petition is just kind of the USCIS review of the family relationship, confirming that, yes, there is a sibling relationship between this U.S. citizen and the person they're sponsoring. But the I-130 approval, that can be filed at any time, but once you're a citizen, but the I-130 approval does not allow the foreign sibling to come into the U.S. It doesn't give them work authorization in the U.S. It actually may prevent them from being able to come in as a visitor, because once the I-130 is filed, that is kind of a official statement that the sibling plans to immigrate permanently into the U.S. And so it could affect their ability to get a B-1, B-2 visitor visa, because the government will always suspect are you really going to depart after this temporary visit? Because we already know you plan to immigrate permanently to the US. So those are all kind of things to keep in mind, actually. You may want to consult an immigration attorney to kind of discuss all those scenarios before filing an I-130, because once the I-130 is filed, like I said, it's officially on the record that this sibling plans to immigrate to the US. So you want to make sure you're aware of all the scenarios. If it's going to be an 18-year wait, they may have to be prepared to not even be able to come in to visit for 18 years, if that's how long it takes.
Okay. Thank you. Thank you so much.
Right. Thank you, sir. Thank you so much for calling, Andy. All right, folks. As always, we keep running out of time on this show. Rebecca, thank you so much for being on the show today and for being so patient with all our callers and all the questions that you've taken on the live chat as well. Really appreciate that.
Sure. Thank you for having me.
Thank you so much. And to all our viewers, we'll be back same time, same place next week. Please come back with your questions. And like I always mention, please try to give us a call because it's easier when you have follow-up questions, or if any of your live chat questions are missing any snippets of information that are critical in, our expert being able to give you like a full picture answer, then it's easier if you're on a call to give us the information that may be missing on your question in the live chat. So definitely keep that in mind. But we'll be back same time, same place next week to take all your questions. Until then, have a great week, have a safe week, and we'll see you then. Bye.
ఆకర్షణీయమైన చీరలు, అప్పురపరిచే ధరలు, అందరికీ నచ్చిన, అందరూ మెచ్చిన షో మన లక్కీ మహిళ. బోలెడంత ఎక్సైట్మెంట్, వండర్ఫుల్ విన్నింగ్ మూమెంట్స్.
ఎగ్జాక్ట్ చెప్పారు. మీరే గెలుచుకున్నారండి. కంగ్రాచులేషన్స్. $220.
సెలబ్రిటీ హోస్టులు, అదిరిపోయే పంచులు, సరదా సరదా కబుర్లు.
ఆశ దోశ అప్పడం వడ హెల్ప్ మీరు ఆడుతున్నారు.
ఇలా మరెన్నో మెమరబుల్ మూమెంట్స్ తోటి 3rd యానివర్సరీ జరుపుకుంటోంది మన లక్కీ మహిళ. Watch it live only on TVASIA Telugu. మీ అందరికీ 3rd యానివర్సరీ శుభాకాంక్షలు.